if the government had stated up front that TraceTogether data would be used for the 7 categories of serious crimes only, they would have been prepared to prioritize the use of TraceTogether because of the imperative of fighting an epidemic. Even those who could have had residual privacy concerns could have been assuaged had the government detailed the processes and accountability regime for using TraceTogether information in investigations. Why was there disquiet, unhappiness, and even cynicism in some quarters at the government's belated acknowledgement that TraceTogether can be used for criminal investigations, as originally explained by Minister of State Desmond Tuan in Parliament last month? It comes down to a question of trust, the perceived lack of empathy over the public's privacy concerns, and discomfort with sharing mobile phone data with the authorities without sufficient assurances. In fact, from a very early stage, the government clearly contemplated that there would be privacy concerns with the use of TraceTogether for contact tracing. In his broadcast of 21st April 2020, the Prime Minister said that Singapore intended to make full use of IT, including TraceTogether, which would require everyone's cooperation. He added, and I quote, "There will be some privacy concerns, but we will have to weigh these against the benefits of being able to exit from the circuit breaker and stay open safely," unquote. In the months that followed, the public were told that the number of sign-ups to TraceTogether was not satisfactory. As late as November, the multi-ministerial task force linked transiting to phase 3 in our fight against COVID-19, with requiring at least 70% of the population signing up for TraceTogether. Since then, and along with the issuance of TraceTogether tokens, this minimum 70% threshold was reportedly reached on 21st November 2020, even as it had been hovering around the 50% mark around 2 weeks earlier. When Minister Vivian Balakrishnan admitted in Parliament that he did not consider Section 20 of the Criminal Procedure Code at the next sitting of Parliament on the 5th of January this year, there are Singaporeans who opine that this was not fathomable or even believable for a largely efficient government machinery that has consistently approached COVID-19 as a whole of government endeavour. They further contend that if not ministers, at least the officials in the Ministry of Home Affairs, the Ministry of Health, and GovTech who conceived of TraceTogether would have known of the privacy considerations surrounding TraceTogether. Some go a step further in suspecting the government of willful blindness on function creep, or worse, that the information surrounding the use of TraceTogether for criminal investigations may have been suppressed until the threshold of 70% of the population had downloaded the app or collected the TraceTogether token. A separate group of Singaporeans query whether there will be consequences for those who made this mistake in promising wrongly that TraceTogether would be used only for contact tracing. They believe the government did not do its homework. While there was no dishonesty or malice, there was a lack of care or diligence in accurately communicating the potential use of data collected by TraceTogether. I'm sure members have come across a range of opinions from residents in the course of their house visits or interactions with family and friends over the last few weeks on this matter. Whatever the view, it is apparent that the government's handling of this matter has eroded trust from some members of the public. To this end, I would like to ask 2 questions of the government, and specifically Minister. First, what was the exact date on which Minister in charge of Smart Nation knew that Section 20 of the Criminal Procedure Code would apply to TraceTogether? Secondly, and in connection with this, was Mr. Christopher D'Souza's parliamentary question submitted before or after the Minister became aware of Section 20 of the Criminal Procedure Code? These questions are important for the House to understand at what point the government determined that its original representations on the use of TraceTogether were misleading, and whether it could have corrected the position and updated the public on its own initiative. Let me now move on to my second topic, the carving out of the 7 categories of crimes and the Workers' Party's position on the bill. The Workers' Party's starting point on this matter is that Singapore is as close to a wartime scenario as most Singaporeans have seen in our lifetimes. This pandemic is exceeded in the living memory of older Singaporeans only by the far greater oppression of World War II. In terms of its effects on the national consciousness, COVID-19 is perhaps on par with other upheavals such as the 1964 riots and Singapore's ejection from Malaysia in 1965. Its scale and complexity have surpassed the SARS crisis of 2003. In such a wartime scenario, the core question for this House is whether the change in the government's position on TraceTogether data to allow for its use for serious crimes could compromise the fight against COVID-19 and jeopardize contact tracing. I will make 2 points in this regard. First, while we know that TraceTogether data is critical for contact tracing, we need to ask whether TraceTogether data is vital for solving these 7 categories of crimes. As it stands, the police have an abundance of investigative tools. They have other technological tools like CCTVs. They can forensically examine mobile phones and laptops that contain massive amounts of data other than TraceTogether. They also have old-fashioned police work, such as finding and interviewing witnesses, using confidential informants, scrutinizing the crime scene, and collecting physical evidence for forensic analysis. There is a legitimate view that these tools should be more than sufficient in detecting crime and securing convictions. To know whether these other tools are enough, I would like to ask the Minister 2 questions about the use of TraceTogether data for actual cases. A, for the one known case where TraceTogether was used, was the case solved in that a suspect has been identified or charged? And how critical was TraceTogether data to solving the case? B, how many other times has TraceTogether been used for the 7 categories of serious crimes so far? There is little or no doubt that TraceTogether would make things more convenient for the police. But it is my view that convenience for the police may not be a good enough reason to compromise the trust necessary to win the COVID-19 fight. There is an equally legitimate view that with the existing tools at their disposal, the police are likely to have very little, if any, additional benefit from using TraceTogether data. I look forward to hearing the Minister's answers to my questions so that we can know for sure the answers will allow members of the public to appreciate the balance that is being struck between privacy and policing.